Matter, Adrian Stenson. I believe Adrian is here. Are you there with your grandmother, Adrian?
Yes, Your Honor.
All
Your
right.
Honor, his mother, Serena, is also present.
Okay, all right. I do see her as well. Okay. Prosecutor is here. You've waived an attorney. Ms. Johnson, this is a show cause. What brings this matter before the court?
Your Honor, there's a couple reasons we're before the court today. First being, Adrian has provided a dilute sample to Great Lakes screening on February 6th. And then on March 12th, the probation department took him to Great Lakes screening. He was unable to provide a sample. He was notified that it would be a positive test. He stated it would be positive anyways. He was very rude and disrespectful towards the staff at the testing site. I did chat with him about that. And then it's been reported that Adrian Connor, two other juveniles, had contact with an officer from Gaylord City Police Department on Thursday, April 4th, regarding the possibility of a stolen shopping cart. I have requested that police report and have not received it yet. And then on April 8th, I was advised that Connor and Adrian were asked to leave the funeral of a former Gaylord High School student. Both juveniles left without incident. On April 9th, it was reported that Connor was over at Adrian's house. Trooper Helton went out and dealt with the situation, removed Connor from the home. The issue with Connor and Adrian hanging out is we've got two juveniles that are on probation. They've had multiple encounters with the police and their choices aren't great. And then on April 10th, Adrian had a disagreement with me. He wanted to drop out of school, get a job, work full-time. I told him that was not an option. School's mandatory, even though he is seeking entry into MYCA in the summer. He didn't like that I told him he couldn't drop out of school and just work full-time. He did leave the court without permission. His location was unknown, and I ultimately called his grandmother, who stated she had custody of Adrian at the time.
All right. Adrian, do you understand what this hearing is about?
Yep.
What?
Yes.
Okay. Adrian, I will tell you respect is required. I will give you respect. I expect the same thing. If not, we will stop this hearing and we'll resume it in person. Do you understand that?
Yes, Your Honor.
Okay. All right. Here are the rights that you have for this. You have the right to an attorney. I know you gave one up in the past, but if you want one, I would appoint one for you. You have the right to a hearing where probation would have to show these things were true by a preponderance of the evidence. If they could not do it, it will be dismissed. At that hearing, you'd have the right to have you or an attorney ask questions of witnesses against you and to have the court order your own witnesses to be present. Do you understand your rights?
Yes, Your Honor.
Do you want to have an attorney or do you want to go ahead without one?
Go with that one, sir.
All right. If you'd raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, and you can put your hand down. Did you hear what Ms. Johnson just said?
Yes.
Are those things true or not true?
May we go over the list one at a time?
Sure. Why don't Ms. Johnson, if you could, I didn't write everything down, so if you could go through them, as you go through, I'll ask after each one what Mr. Stinson's response is.
On February 6th, Adrian provided a dilute sample to Great Lakes screening, meaning he had a positive test. It was sent off to Redwood Toxicology. They did the testing. It was a positive test, but came back with a diluted sample.
All right, let's skip that one as he's not going to know what Redwood did. Let's move on.
Okay. On March 12th, nope, I apologize, Your Honor. On April 2nd, Adrian was advised he would need to drug test on April 3rd. He did not show for that drug test. So on April 4th, the probation department transported Adrian to the drug screening facility. Adrian could not provide a sample. He was told that it would be considered a positive test. Adrian stated it would be positive anyway. Adrian was rude and disrespectful toward the staff at the testing site. While at the testing site, I did talk to Adrian about his behavior.
All right, Adrian, is what Ms. Johnson said about April 2nd and April 4th true?
So she said about me missing drug test is true. That's true. Me having a positive drug test is true anyway. Yes, it was going to be positive anyway. I wasn't trying to be disrespectful, and quite frankly, I don't remember ever even talking to them except for when they asked me to sign. I hear them say that, so I asked, "Do they need me to sign?" And then Samantha yelled at me saying, "Quit having an attitude," when I didn't have an attitude. So that's my only comment on that one.
All
But
right,
you and
I will
wrong.
find that you fail that you, I will find you responsible on that one. I'll take into account what you said about the disrespectful charge portion of that. Ms. Johnson, what's the next item?
It was reported that Adrian Connor and two other juveniles had contact with an officer from Gaylord City Police Department on Thursday, April 4th, regarding the possibility of a stolen shopping cart.
All
Yes.
right.
Then I
So
will.
were you with Connor Lacey on that
Yes,
day?
I was with Connor on that day.
All right. Okay, I will find you responsible on that. Ms. Johnson, move on to the next one, please.
On April 8th, Connor and Adrian were asked to leave a funeral of a former Gaylord High School student.
All right.
So
Were you there with Connor at that point?
yes, I went to the funeral to pay my respects because he was my middle school bully. I
Okay.
paid my respects, but we got asked to leave. We didn't do
All
anything
right.
wrong. Understand
I,
what we
I
did.
understand, and I have no problems, obviously, with you being at the funeral. That's appropriate. But were you
Yes,
associated with
Your Honor.
Connor there at that funeral visit?
Yes, Your Honor.
Okay. All right. All right. Thank you, Ms. Johnson.
On April 9th, Connor was at Adrian's residence. Trooper Helton went out, dealt with the situation, removed Connor from the home. April 9th, I had also had the discussion with Adrian earlier on in the morning about how him and Connor were not to be hanging out. And obviously later that afternoon, Connor was at his house.
All right, Adrian, is that true?
Connor was at my house. I did not expect him to show up at my house. I thought he had already gone home. When he had showed up at my house, I had not known.
All right, did he come in your house?
Yes, he did, because I didn't.
Did you let him in?
Yes, because I didn't really know what else to do.
Had you had that conversation with Ms. Johnson earlier that day about not hanging out with Connor?
Yes, I didn't know if he had that same conversation, so I didn't know what to do
Well, it
about.
doesn't matter whether he had that conversation with him. You let him in the house when you knew you weren't supposed to. That's what this hearing is about. All right. Ms. Johnson, next.
On April 10th, Adrian and I had a disagreement about schooling. He left the court. His whereabouts were unknown. I called Gina, his grandmother, and she had stated he was with her at that time.
All right, Adrian, is that true?
I did not have a disagreement. All I had done was ask a question, and then I got put on with having an attitude when I never had an attitude. And then I got threatened with detention center, and then you slammed the door on me. So then I left because I wasn't going to deal with that. Did I have to leave? No, I take full accountability for leaving. But I just went, oh, I get it. You did not know where I was at. I take accountability for that. But I just left. So I take accountability for that.
Adrian, do you think you were disrespectful to me at the start of this hearing?
Yes, Your Honor.
Okay. All right. Well, I will find you responsible for the probation violations. I will take into account your statements on that. Ms. Johnson, what are your recommendations?
Adrian be placed on a tether for a period of 14 days. Adrian have no contact with Connor Lacey until further discretion of the probation department. A 7-day stay at Isabella County non-secure detention home be held in abeyance pending any further probation violations.
All right. Adrian, do you know what being held in abeyance means?
Nope. I have no idea, Your Honor.
Okay, what that means is, the recommendation is a 7-day stay at non-secure detention held in abeyance, which means you don't do that right now, basically pending good behavior. In other words, you will never do it if we don't have any further significant incidents. If we do, you will do it. That's what it would be. That's what being held in abeyance means. When people are adults, they often get jail time held in abeyance. Like, for instance, I might say 30 days in jail, 5 days up front, 25 days held in abeyance. They never have to serve that 25 days if their behavior doesn't deteriorate. So I want to make sure you understand it. With that statement, do you understand the rest of her recommendations?
Yes, Your Honor.
All right, is there anything you want to tell me before I rule on them?
No, Your Honor.
All right, Ms. Weber, is there anything you wanted to say?
No, Your Honor.
All right, and ma'am, and I apologize if I don't have your name, Adrian's grandmother, is there anything you want to say?
No, there isn't,
Okay.
Your Honor. Thank you.
All right, Adrian, the contact with Connor, and I know Ms. Johnson was clear to you. You said you understood it. Connor will make his own choices, but you cannot have contact with him. You cannot do anything to encourage it, to let him in. And I would tell him, and I'm going to tell him the very same thing. That's a violation. It's a standard provision. Don't hang around with other kids who are on probation. There was the positive test or the test that would have been positive. You are, other than their very first comments to me, you're acting in a respectful manner, and I appreciate that. We all can make mistakes. Being respectful goes a long way in that regard. I'm going to adopt the recommendations. I would really like this to be the last hearing that we have to deal with these, because if we're back here again, it's very likely I'm going to be asked to place you in detention down in Isabella County, which is in the Mount Pleasant area. I don't want to do that, but I will if I have to. So I will adopt the recommendations, including the 14 days of tether and making it crystal clear, no contact whatsoever with Connor Lacey until such time, if ever, as probation says explicitly that it is all right. Ms. Johnson, anything else at this point?
Your Honor, I ask that Adrian and his grandmother remain in our multi-purpose room, and when court wraps up, I will be down to place that tether.
All right. There's another hearing or two that Ms. Johnson may be part of. Once those are concluded, Adrian, she'll be down there. That would be, that'd be the order of the court. All right. Thank you. And I know there's a gentleman sitting at the jail, but I do have one other juvenile matter I have to address first, which I'm going to, and that would be the matter of Connor Lacey. Is he here?
Your Honor, I
Yes.
did not. Oh, he is here.
All right, there he is. All right. All right, Ms. Parker, would you, I'm sorry, excuse me. Ms. Johnson, would you indicate what brings Connor before the court?
Your Honor, kind of the same thing as last hearing, with a couple add-ons. On April 1st, Connor was hitchhiking to Adrian's residence when Officer Gertz from Gaylord City Police stopped him. Officer Gertz searched Connor. At that time, he had a THC cart and a vape pen on him. These items were confiscated, and Connor was returned home. On April 2nd, Connor was advised that he would need a drug test following day. Connor failed to show up for his April 3rd drug test. On April 4th, the probation department transported Connor to Great Lakes screening for the drug test. At that time, his test did come back positive for marijuana. The urine has been sent to Redwood Toxicology pending THC levels. Again, Adrian and Connor were together with two other juveniles, had contact with a Gaylord City police officer on April 4th regarding the possibility of a stolen shopping cart. A police report has been requested for this incident. I have not received that yet. Adrian and Connor were asked to leave the funeral of a former Gaylord High School student on Monday, April 8th. They were both compliant and left without incident. On April 9th, I was made aware that Connor was at Adrian's residence. Trooper Helton went out, dealt with that situation, and had Erica come pick up Connor and transport him home. And that's where we stand with Connor.
All right. Mr. Brown, how would you like to proceed on this?
Your Honor, I have not had any communications with Connor. I did speak with his mother. I'm not sure where he's at right now.
Your Honor, can I just waive the right for my attorney? I'd rather just get this on so I can go work, please.
Well, that's, if you needed an adjournment, I would give you that, but do you want to talk to your attorney briefly?
No, Your Honor. I'm okay to continue forward.
Okay, we'll go ahead. Your attorney will remain here, Mr. Brown. If you believe something is being brought up that shouldn't be, please interject if you would.
Yes, Your Honor.
Connor, if you raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can put your hand down. Did you hear what Ms. Johnson said?
Yes, Your Honor.
Are those things true?
Yes, Your Honor.
Is there anything else you want to tell me about those incidents?
No, Your Honor.
All right, I will accept the admission to these. Ms. Johnson, what are your recommendations for Connor?
Connor be placed on a tether for a period of 14 days and be home by 9 p.m. nightly. Connor have no contact with Adrian Stinson until further discretion of the probation department. May course corrections challenge camp be held in abeyance pending any further probation violations.
Okay. All right, Ms. Brooker,
Your
any
Honor.
comments? Go ahead, sorry.
I would like to make a statement as well.
Go
With
ahead.
this tether, Connor was made aware that the tether could be a possibility. Connor did note to Miss Howard that if he was placed on a tether, it would take 2 officers to place that because he wasn't going to go on a tether. And he would have to
Your
strap.
Honor, that was, I meant that
Hold
by
it.
a joke.
All right, okay, Connor, you'll get a chance to respond. I will give you that chance. I want to hear what Ms. Johnson has to say, then I will hear what you have to say.
Yes, sir.
All right, go ahead, Ms. Johnson.
Regarding Connor's tether, it was stated to Miss Howard that if Connor was put on a tether that he would, it would take 2 officers to place that tether because he would fight the placement of the tether. And then if the tether was placed, he would just cut the band.
All right, Ms. Brooker, and I didn't ask you on Stinson, I apologize, but did you have any comments on the matter?
No, Judge, I don't. It seems like the recommendations in both cases are pretty similar, so I don't have anything additional to add.
All right, Mr. Brown, any comments?
No, Your Honor.
All right, Ms. Walls, anything you wanted to say? You're muted. I can't hear you, ma'am.
I'm sorry, Your Honor. I just want to know where Connor is at.
Right now?
Yes,
Connor,
yes, sir.
where are you, Connor?
I'm sitting at my boss's house trying to go make some money once I'm done with court.
Okay, all right. All right, Connor, anything you want to say about Ms. Johnson's recommendations?
No.
You started to say something about her comments, or the comments you made about the tether?
I
you-
meant it by a joke, but it doesn't really affect me. If they want to have 2 officers there, it doesn't affect me by any means.
Okay, well, Connor, those are things you don't joke about because the court has to treat those as not being a joke.
You're right, Your Honor. I didn't expect my PO to actually recommend those, so that's my bad. But I also have
Okay.
another question. Do I have to go in today to put that on, or what day do I have to be in?
Well, we'll get to that in a minute. I got a couple other things I want to say. You may have heard, I just spoke to Mr. Stinson, to Adrian, and I was crystal clear with him. And just so I want to be crystal clear with you, no hanging out with him until the probation officer, if ever, says explicitly to you it's okay, or until you're off probation. I just need you to understand it. You don't have to agree with it. You just have to follow the rule in that regard.
Yes, sir.
Now, if he tries to get a hold of you, he's the one who gets into trouble. If you
Okay.
try to get a hold of him, you're the one who gets into trouble. I don't want to do that. I don't want to have that there.
Okay.
The second thing is the Michigan Correction Challenge Camp be held in abeyance, and I explained what held in abeyance was to Adrian. Do you understand what being held in abeyance means?
Yes, sir. I've known that since the first time I was on probation.
All right, and then there is the tether. You had a question about the tether.
Yeah, when do I have to put this thing on? Like today?
Are you at work? Are you at work right now?
I'm going to go help out my boss do some things to make some extra money, yes.
And is that like right now that you plan to do that?
As soon as I'm off of court, yeah, but I could probably be up there before they close.
Well, let's see. What's the latest you could get there today for that to be put on, Ms. Johnson?
I would say no later than 4:15.
Can you get here by 4:15? That's 2 hours.
Yes, I can.
I'm fine with that. Connor, you're kind of on the edge. I mean, you're a good kid. I like you, but you're kind of at the edge of being disrespectful today.
I'm sorry, Your Honor. I'm just trying to go work. That's all.
Okay, I understand that, and we'll get there sooner but just act respectfully. That's for everyone. And I have one other question for you. Your screen name is Dagger. And that's in a way can be kind of cool, but it's not something for court, okay?
That's my username. My phone was bugging out and it wouldn't
Okay.
let me log in for a
Okay.
minute.
All right.
I had to keep naming it,
Okay,
so it just.
I'm fine with that. I get that. I understand that. Just a comment there. All right. So Connor, let's not have any problems. When the tether is put on, let's just get the tether done with, do the 14 days and just straighten up a bit, okay?
Yes, sir.
You can do that, because
Yes, sir.
otherwise I have to go on to Plan B and I don't want to do Plan B.
Yes, sir.
So make sure you get here by 4:15.
Okay.
Okay, all right. Ms. Johnson, anything else?
No, Your Honor, thank you.
Okay, and I do think that takes care of the juvenile portion of the docket that, so we'll move on to Mr. Sanborn. Can you hear me, sir?
Judge Cooper,
Yes.
Yes.
Afternoon, Your Honor.
just so you're
Yeah.
aware, Mr. Brown had to step away to do a circuit court hearing real quick. I didn't know if he was
Okay.
for these hearings.
Yeah, he would be.
He'll be back.
Mr. Day, can he hear me now? Do you know?
I believe so.
All right, because
I
I
can
can
hear.
probably do Mr. Day's matter.
Okay.
Mr. Day, can you hear me?
Yep. He's here.
Okay.
Yep. Here, he's.
Okay. that's
Hello,
fine.
sir.
All right, Mr. Day, I know I said I was doing another case, and I apologize, Mr. Sanborn. We definitely need Mr. Brown here for that. Mr. Day is not incarcerated, so it's not quite as
I
important.
know, I tried to get a hold of you at
Okay.
like 1:27, but my phone wouldn't let me get through.
Okay, all right. This is fine. This is fine. So I'd like you to listen now. I've got some things to tell you on this arraignment. This is an arraignment where you're advised of charges against you. The allegations are that on April 14th, count one, that you possessed firearms because you were convicted of OWI third in the past. You are not eligible for that. That's charged as an habitual offender, fourth offense, so you could face